Hello guys. I hope you guys are doing good and you guys have completed our last 3 days of sessions as per our schedule. Marathons. I hope you guys have watched and I hope you have seen the most important topics and you have also covered the case laws. They please go and see the It's the least no we can do. Yes or no? At least make the maximum utilization of all those resources. Yeah. So today's agenda, people, let us solve at least 5 MTPs. See, good enough. At least in one paper, 20 questions, 22 questions will be there. So sit back and relax. Wherever you guys know the answer, pause it and you only try to tell. And then see the solution what I'll be telling. See if there is a match. By that you will be end of the day in this whatever the video duration, you'll be able to cover 100 questions. No, good, right? Okay, let's start. So we are doing 5 MTPs for today, and that will be the agenda. Tomorrow it will be 5 RTPs. Yep. Okay, so let's start. PQR jointly promised to pay S a sum of 60,000. Examine considering the provisions of Indian Contract Act 1872. Can S compel any of the three parties P, Q and R to pay him 60,000? Is it possible? Answer is yes, it is possible. Remember, joint promisors is one of the important topics. In our most important topics, I have put this also. So whenever there are three joint promisors, can the promisee, that is, imagine if there is a creditor, can he recover money from any one of the person? The answer is yes. Now imagine, can I compel can S compel any of the three parties? Imagine, can I compel P alone? Yes, you can compel, but P can later on recover it from Q and R. Possible. R is compelled to pay the whole of the amount. R is compelled to pay it sums. Okay. To S, can he recover from P and Q? Yes, possible. Agreed? Oh, they have given sub scenarios. When both P and Q are solvents, when they have money, of course you can recover. P is not in a position to pay anything. Meaning, let us imagine P has become insolvent. When you have become insolvent, people, then I cannot recover. In such case, what will happen? Q and R have to bear the loss. So you need to pay 30,000 each. Try to show this number and put it in your exam. Instead of just saying that whether you can recover, you cannot recover, tell them how much you can recover, how much you cannot recover. Be very specific. Getting the point? Now here I am just discussing the solutions. I am not discussing how to write and all. Day after tomorrow, that's the last day of our Mission 80 series. The last day, people will be seeing on how to present it. Now I'll be taking up these questions and I'll also try to write along with you. Try to learn how to write that time. Yep. Now let us focus on solving more and more questions inside the class. Okay, because remember, the key for your law is, people, the more questions you see. Second one is the art of writing. You need to get these two. Okay, next one, Oakwood Private Limited is a holding company of Silver Oak Private Limited. Okay, Oat is a holding company of Silver Oak. As per the last profit and loss account for the year ending of Silver Oak Private Limited, its turnover is 1.8 crore. Its turnover is 1.8 crore and paid up capital is 80 lakh. The board wants to avail the status of small company. Possible. A CS the company advised the Silver Oak cannot be categorized. Please give your possible people. What is small company, people? As per section 2 clause 85, a company other than public company whose paid up capital does not exceed 4 crore, turnover does not exceed 40 crore, but it does not include holding, subsidiary, statutory and section 8 company. Silver Oak is a subsidiary company and hence Silver Oak cannot be categorized as what? It cannot be categorized as small company. So yes, company secretary's contention is valid. In the Blossom Private Limited, there are only 5 members. All of them going in a boat on a pleasure trip into a open sea. The boat capsizes and all of them died being drowned. My God. Explain with reference to the provision of Companies Act. People, what are they trying to tell you? They are talking about, people, perpetual succession. So once a company is a separate legal entity, perpetual succession, members may come, members may go, but the company will go on forever. So in this case, the legal heirs will get the right to carry out the company. Is it no longer in existence? No, it will continue to be in existence because it's a perpetual succession. Is it correct to say that a company being an artificial person cannot own property and cannot sue or be sued? No, this is incorrect. A company is an artificial person and recognized as a body corporate in the eyes of the law, and hence it is eligible to hold property in its name, can sue, be sued. Explain the rules laid down under Indian Partnership Act for the mode of settlement of partnership accounts after decision of what is the order in which assets of the firms are applied. How it is, first people, losses if any, mode of settlement of partnership accounts after dissolution of a firm. So what do we do? First we will repay third parties debts. Next, loans and advances, anything over and above capital, and then capital, and anything surplus will be distributed. Discuss the provision of Indian Partnership Act regarding the payment of firms' debts and separate debts. The firm's properties will be used to first repay the firm's debt and then separate debt. Whereas on the other end, the separate debt of the partners will be used to first repay the separate debt of the partners, and if there is still excess, then it will be used to repay the firm's debt. Correct? Done. The Institute of Science and Technology, Dehradun, placed an order for various chemicals worth 1,50,000 from a supplier in Delhi. The buyer made full advance payment and the seller dispatched the consignment via courier of his own choice without reserving any right of disposal over the goods. The consignment was lost in transit, and now the buyer seeks a refund for the purchase of the price with reference to the provision of Sale of Goods Act. When does the ownership pass? People remember, when does the ownership pass? Whenever the goods are given to a courier, whenever the goods are given to a carrier, and if the goods are ascertained and unconditionally appropriated, and there is no right of disposal reserved. So if at all that carrier, the courier, if he is appointed by the seller or not, if the goods are given to him, then the goods are considered as if it's unconditionally appropriated. So the ownership passes, people, the moment it is given to that person. So because the goods are given, so A is selling some goods to B by a courier. It is shipped by a courier. People remember, payment and delivery is irrespective. If the goods are appropriated and if it is clearly given without reserving a right of disposal, people, that's all, it's done. The goods are appropriated. The ownership is passed. So can you recover the loss? Answer is no. Siddharth visited an authorized car showroom and purchased the car of his own choice without conducting a detailed inspection. After making the payment and taking delivery of the car, he discovered a defect in the engine that could not have been detected even with a reasonable inspection. With reference to the provisions of Sale of Goods Act, advise whether Siddharth can invoke the implied condition of merchantability and repudiate the contract due to the defect in a car. Yes, people, possible, because these are called as what, people? Latent mistakes, we call it. Meaning, even if you check, if you cannot identify it, we call them as, people, hidden or latent mistakes. So such things, people, yes, you can invoke the implied condition as to merchantability. What do you mean by merchantability? The product that you are buying, people, should always be free from defects. Yes, can I? Yes, I can. Agreed. Explain the classification of capital. What is this? The authorized capital, issued capital, subscribed capital, called up capital, paid up capital, that one. Direct ones, let us not go through. Explain advantages of LLP form of business. Whatever you write for company, write the same thing, it will still be valid. P, Q and R are the partners in a construction firm. P, Q are associates. P buys the cement on behalf of the firm from D. The cement is used in the ordinary course of the firm's business. P uses the cement for his personal purpose. The supplier D, who is unaware of the private use of the cement by P, claims the price from the firm. The firm refuses to pay for the price on the ground that the cement was never received by it. Referring to the provisions, answer whether the firm's contention is tenable. What would be your answer if a part of the cement so purchased by P was delivered to the firm by him and the rest of the cement was used by him for his private purpose? about which neither the firm nor the supplier were aware. So what is happening, people? One partner takes cement, and cement is used by the partnership firm in the ordinary course of business. So remember, a partnership firm will always be liable if the goods are purchased or if any contract is entered by any partner in the ordinary course of business, meaning cement is their everyday activity. Second one, people, the partner should have acted within his authority, within the scope. In such case, any contract entered by P, the firm will be liable provided if that particular contract was entered in the name of the firm. So P has clearly said, I am a partner in PQR firm, I am borrowing this cement for the firm. So in this case, people, whether PQR, will they be liable? Yes, people, the firm is liable. Mutual agency. Agreed? Yes. Sir, what if half was given to the firm and half he used it? Even otherwise, you are liable for the full thing only. If that particular cement was purchased in the name of the firm, in the ordinary course of business, the firm will be liable. Any misappropriation will not stop the liability of the firm. Firm will be liable. Later on, can I file a case on P? Yes, sir. Amongst you guys, you can file a case. But you cannot file a case, or you cannot exclude your liability from the third party. Unity Foundation is a newly incorporated company focused on promoting education and healthcare services in rural areas. The company is registered as Section 8 company. It's a Section 8 company. Okay. With a clear plan to reinvest all profits into activities. Very good. And the license has been accorded by the central government. Very good. For the financial year, the company earned a substantial profit and transferred some amount to measures ABC Associates, a partnership firm, and one of the member in that particular Section 8 company. Okay, they have transferred some profits to a partnership firm which is a member in this particular company, it seems. Remember, only exception, a Section 8 company can become a member in, a partnership firm can become a member in Section 8 company, or else generally partnership firm cannot become a shareholder. Only exception is Section 8 company. And transferred some amount to measure. Okay. Subsequently, on the complaint of one of the members, the central government, after giving an opportunity of being heard, directed the company to be wound up. That a partnership firm cannot be a member of Section 8 company and it cannot transfer any part of the profit to the firm. Explain the right of the provisions of Companies Act. People, what has happened here, people? There is a Section 8 company. In this Section 8 company, there is a shareholder, and that shareholder is a partnership firm. First problem they have is, can a partnership firm be a shareholder in a company? Answer is yes, we don't have a problem. On this, you cannot wind up that partnership. You cannot wind up a Section 8 company. This is not any non-compliance. It is in proper compliance only. Second one, people, can a Section 8 company give any part of its profits to any person? Forget about partnership. Can you give it to any person? No, people. Distribution of dividend is always prohibited in a Section 8 company. On this ground, people, the Section 8 company has done a violation. So central government may pass an order if it deems fit. Yes, the central government's order will be valid. Simple. Okay. Pacific Private Limited has 9 directors on its board. The company's articles of associations currently state that the quorum for board meeting is 1/3 of the total strength or 2 directors, whichever is higher. The company now intends to amend this article to specify that the quorum for board meeting shall be 1/3 of the total strength or 4 directors, whichever is higher. Currently it is 1/3 or 2, whichever is higher. They want to make it 1/3 or 4, whichever is higher. Possible? Yes, people, remember, this is only called as nothing but, yes, what? Section 5, people, entrenchment of articles of association. If at all, people, okay, it's a Pacific Private Limited. How can a private company entrench its articles of association? By passing a resolution which is accepted by all the members. All the shareholders have to agree. Would your answer be different if the company is public company? Yes, my answer will be different. If at all it is a public company, for the entrenchment of articles, special resolution has to be passed. Once it is passed, kindly intimate ROC, and then yes, this particular changes will take place. Is clear all of you? And the provision they're asking you people is on entrenchment of articles. If you guys remember, see, in the most important topics, all this I have told you to study. Entrenchment and all. Don't leave it. What is an anticipatory breach? Before the due date, if the contract is called off, anticipatory breach. Okay. Examine the validity of the following agreements under the Indian Contract Act. Ms. Deepika pays a sum of 20,000 to a marriage bureau to provide information. Is it opposed to public policy? Yeah. No, people. It is absolutely valid. Remember, marriage brokerage agreements are different from marriage bureaus. They do not do a brokerage. They just sell you the data. So this agreement, this contract is valid. Bharat agrees with Rahul to sell his white horse. Unknown to both the parties, the horse was dead at the time of agreement. Mistake of fact. Both of them did not know. So bilateral mistake of fact. Bilateral mistake, the contract will always become, it's a void agreement. Agreed? Next one. Ayush sells the goodwill of his shop to Omkar for 5 lakh rupees and promises not to carry on such similar business within the local limits so long as Omkar carries on like business. Meaning, sir, A sold his business to B and clearly said that B is telling people, I will buy provided you cannot start a similar business in the same local area. Is this restriction valid? Answer is yes, people. Restriction in, restriction in trade, it will be valid provided people, the restriction is always reasonable. If it is unreasonable, people, then no, restrictions cannot be, it will not be valid. So in this case, what are they telling you? They're telling you cannot carry on a competing business in the local area. What if I can go a little far and can I do? Yes, I can do. They are not restricting me forever or from everywhere. It is only from a particular place. It is valid. A property worth 20 lakh was agreed to be sold for just 2,50,000 by a person of unsound mind. People will just, in rush, they will write off the answer. Sir, the consideration may be inadequate. They will just write that and they'll come off. People remember, unsound mind, the contract of course is invalid. What is negotiable instrument and its characteristics? I think manageable. RBIC, remember and go. MCA, remember and go. Okay. PQR Limited, a supplier of electronic components, entered into a contract on August 1st, 2024 with PQR Enterprises for a sale of 1,000 units of microchips. The contract specifically identified the microchips by serial numbers. So see, what do you mean by that? Amongst the bulk, what they want is already ascertained. So the goods are identified. That means ownership should have been passed. And confirm that they were in the deliverable state. So goods are also in deliverable state and identified. Specific goods. So the contract is made. Ownership is passed whenever the contract is made. Stored in PQR Limited's warehouse. The contract stipulated that the goods would be delivered on September 1st, 2024. Contract is entered on 1st August 2024. So people, I'll tell you, will not even read the question. If at all the goods are in deliverable state and if at all the goods are ascertained and if the goods are appropriated, meaning selected, everything is done. In such case, people, the ownership passes immediately. The payment of price and the delivery of goods are irrelevant. So people, the ownership passed on August 1st only. Anything happens after August 1st, people, the liability will be on the buyer, not on the seller. That's what they are. See, on August 10th, flood occurred, damaged the warehouse, destroyed the entire stock. In such case, who will be liable? Buyer only will be liable. Ownership is passed. Done. A purchases a motorcycle from B and uses it for some time. It turns out that the motorcycle sold by A to B to A was stolen one and had to be returned to a rightful owner. A brings action against B for the return of the prize. Will this person succeed? Implied condition as to the title people. If at all A sold the goods to B, we assume that A is the owner. What if it was a stolen goods? Then people B will have to return the stolen goods to the actual owner. Whoever is the actual owner, you have to transfer it to them. And later B can recover the money from A. This is possible. Is the answer possible? Yes, possible. You can recover the price. Done. What is partnership deed? No, enumerate obligation. Yeah, okay. Kanika purchased various cosmetic products worth 15,000 during the last week from Karthik, a shopkeeper, on credit of 1 month. After a fortnight, she makes out a blank promissory note, signed it, and delivered it to Karthik, who further endorsed it to Manish. Kanika gave a promissory note to Karthik. So she has to make the payment. Okay, what is Karthik doing? Karthik further endorsed it to Manish for the payment of his dues. Manish, who is a holder in due course. Manish is HDC Sims, holder in due course. Filled up the due amount of 17,000. The actual value of Kanika given is 15,000. What Manish has filled in the, it's a blank instrument, no? They have said no. Blank promissory note. Manish filled 17,000. And her maturity presented to Kanika for payment, but she refused to pay because the amount filled up is more than the agreed amount, 15,000. It is to be noted that the amount of 17,000 is covered by the stamp affixed on it. Referring to the provisions of Negotiable Instrument Act, whether Kanika is liable to honor the promissory note to Manish for 70,000. Yes, people, always remember, if you are a holder in due course, you are eligible to recover whatever is the money up to which the stamp duty is covered. Correct? Yes, sir. So, sir, if Karthik had to pay Manish 17,000, if Karthik owes Manish 17,000 and the stamp duty also covers it, people, then yes, I will be liable. I can recover the entire 17,000. Kanika cannot say that I am responsible only for 15,000. Yes, sir, I can recover up to the stamp duty covered. Okay. Nisha, a small business owner, receives a bill of exchange from her customer Neeraj, which is due for payment on October 15th. On October 12th, Nisha presents the bill of exchange for presentment at Neeraj's office during business hours. But Neeraj is not present. Nisha leaves the bill with Neeraj's assistants, requiring to be presented to Neeraj for payment when he turns. However, Neeraj's assistants forgot to give the bill and Neeraj does not make the payment by the due date and the bill is dishonored. Based on the provision of Negotiable Instrument Act, examine whether Nisha's presentment or presentation of the bill of exchange to Neeraj's assistants, is it valid or invalid? Of course it is invalid, people. You have to give it to the person, that is Droyi himself, or to any other person authorized by him. You cannot give it to any random person, even if that person is an assistant or anyone. If they are authorized to take it, you give it. If not, people, you cannot give it. And hence here, yes, not possible. Okay, explain circumstance. Bailment may be terminated. Concept of right of resale. Then easy one. Nothing complicated here. I hope it was easy and breezy. Okay. Next one. I hope you guys are able to answer the questions, da. Okay. Kashish was running a business of artificial jewelry since long. He sold his business to Naman. Kashish was running a business of artificial jewelry. He sold his business to Naman. Kashish sold his business to Naman. Okay. Naman made an agreement with Kashish not to carry on the business with artificial jewelry and real diamond jewelry in that area and for a period Naman made an agreement with Kashish not to carry on the business of artificial jewelry and real diamond jewelry in that area and for a period of next 1 year. After 2 months, Kashish opened a showroom for real diamond jewelry. Real diamond jewelry. Naman filed Naman filed a suit against Kashish for closing the business of real diamond business as it was against the agreement. Whether Kashish is liable to close his business of real diamond jewelry following the provisions of Indian Contract Act. Naman made an agreement with Kashish not to carry on the business of artificial jewelry and real diamond jewelry. Correct? Later on, what did he start? He started real diamond jewelry. Sir, whether the restriction was valid or invalid, restriction was reasonable. I cannot carry it in that area for 1 year. After that, can I carry? Yes, I can carry. Now, in this case, people, whether is the restriction valid or invalid? The restriction is valid. So, can this person can the person carry out? The answer is no, you cannot, because you have clearly agreed that you will not carry on this business of Naman made an agreement with Kashish not to carry on the business of artificial jewelry and real diamond jewelry. But there is only one thing here, people. I'll tell you both, reasonable and unreasonable. I am doing artificial jewelry. That is my business. Why am I stopping you from doing real diamond jewelry? Now that is an unreasonable ground. I can stop you from doing something which I am doing. I can stop you. I can say don't do. But why am I telling you not to do something which is nowhere related to me also? That becomes unreasonable. So on this ground, I will say, people, yes, Kashish is liable to close his business. Whether Kashish is liable, the answer is no. Kashish is not liable because the real diamond jewelry is nowhere in competing business. So the restrictions in that, people, is invalid. Clear? Good question. Okay. Albert obtained 2 loans of 3 lakh and 4 lakh respectively from a reputed bank. Out of these 2 loans, a loan of 3 lakh was guaranteed by Robert. Okay. There were 2 loans taken in since. One is 3, one is 4. Okay. And in this 3 lakh loan was guaranteed by Robert. Albert sent 2 lakh to bank but did not intimate as to how this amount to be paid. So I have repaid 2 lakh, it seems. I did not tell to which transaction to be taken. People, appropriation of payment, people. First, it will always be the choice of the debtor. If debtor is silent, then go as per the circumstance. One is 4, one is 3. So there is nothing for circumstance. The third one is, people, when the debtor is silent, people, the creditor can choose any order of payment. It is his choice. Even if creditor is silent, people, always go in FIFO. That is first in, first out. Okay, the bank appropriated the whole of the money towards 4 lakh. The bank took it towards 4 lakh, it seems. Why? Of course, because for 3 lakh they have guarantee. For 4 lakh they don't have guarantee. So he argued with bank that repayment amount should be first adjusted towards the guaranteed loan. That is, he's telling, no, what it is right, what it is wrong. You have to first set off the money towards 3 lakh and not towards 4 lakh. Now the question is, people, whatever is contention, is it valid or invalid? Of course, invalid, people. When you were silent, when you repaid the loaner, that person, the creditor, can set it off against any order of his choice. So your contention will be invalid. Next one, Parasnath Infra Height Limited is a public company and having 215 members, which 20 members were employees. Okay, 215 members. Limited means it's a public company. 20 members are employees. Were employees in the company during, when were the employees? From 1st June 2022 till 30th June 2024. Only during this period they were employees, it seems. They were allotted shares in Prashant Infra Limited on 1st April 2018. See here, they were employees from 2022 till 2024. But when did they become shareholders? They became shareholders even before they were employees. So I think they will ask you people, can a public company get converted to a private company? They have 215 members. Is it possible? In 215, 20 members are employees. Possible, that is what they would have asked you. Which are held by them today, that is 31st August 2024. Now the company wants to convert itself into a private company. State with reasons whether Prashant is required to reduce the number of members under the provisions of Companies Act. Is it required, people? The answer is it required? Answer is yes, sir, required. Because they became a shareholders of the company even before they were employees. So under private company definition, who are excluded? The employees who are also the members of the company. So people in our case, the employees got the shares even before they were employees. So can I exclude them? Answer is no. Can I include them in the count of members? Answer is yes. So 215 will be considered as 215 only. Done. Okay, Priyansh ordered 600 tins of apple juice from an American company, Am Juice Limited. The company informed that the tins would be packed in the boxes, each containing 50 tins. Company informed that they will pack it in each containing. Okay. On delivery, it was found that a substantial part was in boxes containing only 30 tins. They said we will pack in 50, but they have packed 30. Priyansh rejected the whole order as the tins were not packed according to the description. Okay. State with reasons whether Priyansh can avoid the contract under Sale of Goods Act. Possible? Yes, possible. Because you have given the description that I'll be selling it in the pack of 50, you have sold in the pack of 30. So can I reject? Yes, people. Possible, provided that was agreed between the parties. That is 50-30. So is it possible? Answer is yes, possible. Both LLP okay. Rahul and Kapil are partners in Measure Saxena Marble House. Rahul purchased 100 shares of reputed company in his name, but he made the payment from firm's account. One of the partner purchased the shares with him. He took the shares, but the money was paid from the partnership firm's account. Rahul did not consent to Kapil before acquiring the shares, referring to the provision of Indian Contract Act. Whether shares purchased by Rahul constitute the property of the firm? Answer is yes. What would be your answer if Rahul debits himself in the accounts books of firm and become a debtor of the firm? Meaning, if I'm instead of the firm paying, I will say I will only pay money. Give me some time. If it is shown as a debtor, people, then of course it is a valid contract. Then no problem. Next one, just a second. Just give me 1 second. Yes, people. The next one. Suraj Pharma Limited, a public company, its articles of association empowers the managing agents to borrow both short-term and long-term loans on behalf of the company. Mr. Smith, the director of the company, approached Easy Finance Limited, a NBFC, for a loan of 25 lakh in the name of the company. The lender agreed and provided the above said loan. Later on, Suraj Pharma Limited refuses to pay the money borrowed on the pretext that no resolution authorizing such loan have been actually passed by the company, and the lender should have inquired about the same prior to the providing of such loan. People, if you remember, people, doctrine of indoor management, we need not have to check whether the management procedures are done by the company or not. If you guys remember the case law also, people, Royal British Bank versus Turkian's rule. Can the company reject its claim? Answer is no. Because if you have clearly written in AOA, this is my limit, then it will be binding. If you have not mentioned the limit at all in AOA, then how will the person who is an outsider, how will he know about the restriction? Agreed? Okay. XYZ was incorporated to hold the patent for a new product. Patent means dormant company. Okay. The company is expecting to start its commercial production within the next 2 years. In the meanwhile, for timely installation, the company has placed the purchase order for plant and machinery with a down payment of 1 crore. Possible, significant accounting transaction. Referring to the provisions, whether the company can go for acquiring the status of dormant company, of course no. Because people, significant accounting transaction. So it is not an inactive company. So a company cannot apply for dormant status. Nitin appointed Shiv as his agent to transport apples from Shimla to Delhi. Due to heavy rain in Shimla, Shiv was stranded for more than 7 days. Shiv was not in position to contact with Nitin. To save Nitin from loss, Shiv sold all the apples in the nearby market below the market rate. Explain with reference to Indian Contract Act, can Nitin recover the loss from Shiv? Not possible, people. Agency by necessity. If at all the agent is not in a position to speak with the principal, and if the agent has resorted to the best possible alternative action, whatever the agent does, people, principal will be liable. So principal cannot recover the loss from the agent. Agent by necessity. Explain the concept for presentment. What do you understand by law? Okay. Mr. Shankar sold 1000 kgs wheat to Mr. Ganesh on credit of 3 months. Wheat was to be delivered after 10 days of contract. After 5 days of a contract, a friend of Mr. Shankar secretly informed him that Mr. Ganesh may default in payment. See, it is to mislead you. On the information of friend, Mr. Shankar applied the lien and withheld the delivery. Referring to the provisions, state whether Mr. Shankar was right in his decision. Was he right? Answer is no. When can you exercise right to lien? Whenever the goods are sold on cash basis, whenever the goods are sold on credit basis, but the period of credit is over, whenever the person becomes insolvent. First one, people, it is not sold on cash. So first scenario is not. Second one, it is sold on credit 10 days and you are doing it within 5 days only. So the credit period is not yet over. And people, the friend has said he may default in payment. That means they have not used the word insolvent and the word is may. So you are not sure yet. So because of these things, people, so whether Mr. Shankar was right in decision, answer is no. What would your answer be? See, if he became an insolvent, then yes, you can invoke the right of lien. Clear? Done. Partner in a firm may be classified into dormant partner, nominal partner in profits or holding out. Okay. Sachin bought 1000 kgs sugar from Saurabh for 40,000 on 3 months credit. For this purpose, Sachin issued a promissory note to Saurabh on the same date, payable after 3 months. On the date of maturity, the promissory note was dishonored by Sachin. Saurabh filed suit for the recovery of the amount plus fees of advocate paid by him. Referring to the provision of negotiable instrument, what amount could be recovered from Saurabh from Sachin? Of course, people, you can recover 40,000. That is the amount mentioned on the bill. You can also recover advocate charges, court fees, all of this can be recovered. Yes, possible. The third thing, you are also entitled to an interest at the rate of 18 percentage per annum. Because if you had given me money today, it will be 1 crore. If you're giving it to me after 1 year, I would have utilized it for some other purpose. I would have invested in my FD. I would have got at least some rate of interest, no? Hitting it up. Okay, explain the done. Clear? I hope it is easy and understandable. Nothing, no complicated question as such spotted yet. Mr. A was running an orphanage. His friend Mr. S, a philanthropist, agreed to donate rupees 2 lakh for treatment of a child who was suffering from cancer. On emergency, Mr. A incurred 1.5 lakh on treatment of child. Now Mr. S refused to pay. Whether Mr. A can claim 1.5 lakh from Mr. S possible? Case law, which case law? Kedarnath versus Gori Mohammed. So people, if you remember, what is this coming under? Exceptions to quid pro quo. Charity. So will charity become a legal obligation on you? Answer is yes, charity is a legal obligation provided the other party has undertaken some liability. Based upon your word, if the other party has undertaken some liability, it becomes a debt. You have to pay. Mr. L let out his residential house to Mr. M for 50,000 per month for a period of 1 year. According to the rental agreement, electricity bill will be paid by Mr. L. But Mr. L could not pay electricity dues up to 5 months due to his financial hardships. The electricity board sent the notice of disconnection. If it is not paid within a week's time, to avoid all this, Mr. M paid the electricity bill of 50,000 with penalty. Later on, L refused to reimburse 50,000 and argued that he has paid bill voluntarily because of his own interest. Decide with the reference to the provision of Indian Contract Act. People, they have made your life very easy. Payment made by an interested person. That's the provision. If the landowner does not pay, they will they will seize that particular property, or they will remove the fuse, because of that even the tenant also is suffering some loss. In that case, don't you think I will suffer some loss? So to avoid that, if I'm making the payment, of course people, I can recover the money from you. So will I be able to recover? Yes, payment made by a interested person. Quasi-contracts, yes or no? Okay. XYZ Limited was incorporated to hold the patent for a new product. Company is expecting macha cut copy paste, same thing. Dormant company, plant and machinery, 1 crore cannot be considered as a dormant company. Mike LLC incorporated in Singapore, having an office in Pune, India. Analyze whether Mike LLC could be called a foreign company. What is a foreign company? A company which is registered outside India, a body corporate which is registered outside India, which has a place of business in India and conducts any business activity in India, it will be considered as a foreign company. And hence Mike LLC is a foreign company because it is registered outside India. It has a place of business in India. It is a foreign company. State the modes by which a partner may transfer his interest in the firm in favor of another person. Okay. Sony, a friend of Priya, wanted to buy her two-wheeler. Priya agreed to sell her two-wheeler to Sony, and it was decided that the price of her two-wheeler will be fixed by Priya's father, who is an auto dealer. Priya immediately handed over the keys to Sony. However, Priya's father refused to fix the price as he did not want Priya to sell her vehicle. Priya expressed her inability to sell the two-wheeler to Sony and asked for return, but Sony refused to return the same. Explain, can Priya take back the vehicle from Sony? Will your answer be different if Priya had not handed over the vehicle to Sony? People, this is nothing but people ascertainment of a price. It will be first decided based upon the course of dealing between the parties, based upon the agreement, or based upon the third valuer or the third party valuation. So if a third party, we have said that he will give a value, based upon that we will enter into a contract. But remember people, if at all anyone does any activity because of which the third party is unable to do the valuation, in such case such contracts can be avoided. That is one, remember. Second one people, whenever the goods has been transferred, whenever the possession has been transferred, in such case people, the buyer is expected to pay a reasonable price. You cannot avoid the contract. So in this case, can Priya take back? Answer is no. They will pay a reasonable price. Will your answer be different if Priya had not handed over the vehicle? Yes, my answer will be different. In such case, the contract can be avoided. Clear? Done. LLP, okay. P, Q, and R formed a partnership agreement to operate motor business along specified routes for a duration of 12 years. After operating the business for 4 years, it was observed that the business incurred losses each year. Despite this, P is determined to continue the business for the remaining period. Examine with reference to the Indian Partnership Act, can P insist to continue the business? If so, what options are available to Q and R who are reluctant to continue the operating business? Remember, can P continue the business? Answer is yes. Because it's for 12 years. Only 4 years have passed. So can we continue? Yes, as per the agreement, we can continue. Sir, if you do not want to continue, what is the alternative Q and R has? First thing, people, mutual agreement. All of you guys have to agree and mutually dissolve the firm. If not, people go under the court's route. Perpetual losses. One of the ground for dissolution. The court may order for dissolution order. A and B operate a textile merchant business in partnership. Mr. A finances the business and is a sleeping partner. In the regular course of business, B acquires certain fabric goods belonging to C. However, B is aware that these goods are stolen property. Despite this knowledge, B proceeds to purchase and sell some of these stolen goods. Moreover, B records the proceeds from these sales in the firm's books. Now, A wants to avoid the liability towards C on the ground of misconduct by B. In the light of provisions of the Indian Partnership Act, discuss the liability of A and B towards C. Always remember, people, any wrongful act done by a partner, all the partners will be liable. Partnership firm will be liable. Even though you are a sleeping partner, acting partner, it will not make any difference. In our case, even though you are a sleeping partner, this person's liability will continue. It will not come to an end. XYZ is a company incorporated under Companies Act 2013. The paid up capital is as under. Okay, XYZ Limited. Oh, they have not given anything. Okay, XYZ. In this, Government of India holds 20 plus Government of Tamil Nadu holds 10, 30. Rajasthan 10, 40. LIC don't count. This you don't count. As per above, whether XYZ Limited be called as a government company? Answer is no. People, what is a government company? Where central government or state government or state and central or state governments hold more than 51% of the total voting power, total paid up share capital. We call such company as government company. Nowhere it says you need to add these two in the definition. So total capital is 40% and on those grounds we can say it is not a government company. M and N holding 70 and 30% of shares in the company both die in an accident. Perpetual succession, people, same thing. The company will not come to an end. Company can still continue. Explain in brief with reference to a provision of Indian Contract Act. What are the rights? Okay. Mr. J entered into an agreement with Mr. S to purchase his house for 20 lakh. Within 3 months, he also paid 50,000 as token money. In the meanwhile, in an anti-encroachment drive of the local administration, Mr. S's house was demolished. When Mr. J was informed about the incident, he asked for the refund of token money. Referring to the relevant provisions of Indian Contract Act, state whether Mr. J is entitled to the refund of the money. People, they are asking you as per Indian Contract Act. Do not get confused between Sale of Goods Act, transfer of ownership. First thing, Sale of Goods Act can never have immovable property. They have clearly given you Indian Contract Act. Now, what has happened? Indian Contract Act, contract is entered, but the effect is in the future. So it's an executory contract. Now, people, after the contract is entered, something becomes impossible to perform. What will happen to the contract? Contract becomes void due to impossibility of performance. Why? Because of change in law. And in such case, what happens? It's a void contract and hence the contract comes to an end. Whenever a contract becomes void, remember, whatever advantage the parties have received, the parties are expected to return the advantage received. So you have received the token advance, the money will have to be received. You have to return the money. 50,000 will be given back. Rama directs Shams to sell laptops for him and agrees to give Sham 11% commission on the sale price fixed by the Rama for each laptop. As Government of India puts restriction on the import of laptops, Rama thought that the price of laptops might go up in near future, and he revokes the Sham's authority for any further sale. Sham, before receiving the letter at his end, sold 5 laptops. When will agency come to an end? When it is communicated to the agent, or for the third party, when does it come to an end? When it is communicated to the third party. So here, before it is received, he reads about it, he gets to know about it. He has already sold 5 laptops. Sham asked for 11% commission of 5 laptops at 1 lakh each. So what will be my commission? Whether the sale of laptops after revoking Sham's authority is binding on Rama. So people, after it is communicated, people, after you are aware of it, then people know you cannot bind. But after you are aware of it, will you be able to recover the commission? Yes, sir. How much, people? 5 laptops you have sold for 1 lakh rupees into your commission is what? 11%. 5 lakh into 11%, how much? 55,000. Correct, no? That will be my commission. Write down, see, calculate and show. Inchoate. Okay. Ram sells 200 bales of cloths to Sham and sends 100 bales by lorry and 100 bales by railway. Sham receives delivery of 100 bales sent by lorry, but before he receives the delivery of 100 bales sent by railway, he becomes bankrupt. Ram, being still unpaid, stops the goods in transit. The official receiver on Sham's insolvency claims the goods, decide the case with reference to the provision of Sale of Goods Act. So people, there is one whole contract. In that 100 was sent by lorry, 100 by railway. Lorry has reached, railway has not reached. The person has become insolvent. Can I exercise my right to a stoppage in transit? Answer is yes. For the remaining goods in transit, I can exercise right in transit. Classify the following transaction according to the types of goods. A wholesaler of cotton has 100 bales in his godown. He agrees to sell 50 bales and these bales were selected and set aside. So it is already selected and set aside. Ascertained goods, people, identified goods. Specific goods identified. A agrees to sell to B 1 pack of sugar out of the lot of 100 packets. Agrees, meaning in the future. So it is unascertained goods. Bulk. T agrees to sell to S all the apples which will be produced in his garden in the next year. That means, people, future goods. Referring to the provision of Negotiable Instrument Act, Aman drew the bill of exchange on Baban. Aman drew on Baban, who accepted it, and payable to Magan. Payable to Magan. Magan endorsed the bill to Gagan. Okay, Magan, what are they doing there? Gagan endorsed the bill to Akash. Abba. To be delivered. Okay, Gagan endorsed the bill to Akash to be delivered to him on the next day. Okay, Gagan endorsed, meaning he has signed. And the delivery is to happen tomorrow. However, on the death of Gagan on the same day, his only son Ankit delivered the bill to Akash. So Gagan did not deliver, Akash delivered. On presenting the bill on the due date, the Baban refused to pay, explaining the importance of delivery negotiation, decide whether Akash can enforce the payment of the bill of against Baban on the previous parties or not. Remember, people, endorsement is complete only after signing as well as transferring. Delivery of instrument has to take place by the party only. Upon the death, people, you just like that cannot give away the instrument. That cannot be considered as delivery. It is the same party who needs to give, not the one who has passed away. So no, it is not valid. Understood? Reliable Limited, an Indian company, is a global leader in petrochemical products. For payment of the sale price of machinery imported from Alex Manufacturing Limited, a USA based company, the Indian company drew a bill of exchange on Manish, a resident of Mumbai, who accepted the bill at Mumbai payable to the exporter in Los Angeles, USA. Decide whether the bill of exchange is inland or foreign instrument. Whether it is an inland or foreign instrument, we had seen this in our revision on all the place, people. Inland and foreign instruments are important. First thing you guys have to see, people, whether the bill is drawn in India. It's an Indian company, so of course it is drawn in India. If that condition itself is not satisfied, then close your eyes and write off foreign instrument. Okay, next one. Next two conditions I have to see is what? If it is payable in India or if the drawee resides in India. So this is mandatory. In these two, any one has to be satisfied. So they're telling you drawee resides in India. So one condition satisfied, one condition satisfied. So two conditions satisfied. Hence it is a inland instrument. Done. J, a wholesaler of premium basmati rice, delivered on approval 100 bags of rice of 10 kg each to a local retailer on a sale or return basis within a month of delivery. The next day, the retailer sold 5 bags of rice to a regular customer. A week later, K informed the retailer that the quality of rice was not as per the price. The retailer now wants to return all the rice bags to J, including the 4 bags not used by K. Can the retailer do so? People, sale or return basis. When does the ownership pass? Whenever you signify your approval. Next one, people, you keep the goods beyond the returnable period. Third one, people, you do something equivalent to an acceptance. In this case, what happened? A has sold the goods to B on a return sale or return basis for a month, 1 month. Now B further has sold it to C. Now when can you further sell it to C, people? As per the third condition, when you think that product is yours. So he has sold 4. So out of 100 people, I can return 96, no doubt, but I cannot return these 4 because on that you have already exercised your ownership. So it is the ownership is already passed. That's all done. Next one. X was running a business of car on lease. One fine day, Y came to hire a car for 10 days for his business tour from Delhi to Amritsar. X offered him a Honda City for 50,000 for 10 days on a condition that petrol and toll expenses will be borne by him. Okay. During the journey, engine of car was choked. Y has to spend 10,000 rupees for repair of the engine. Extraordinary expenses, the bailer only has to pay. When he was coming back from Amritsar, the brakes of the car were not working and a major accident also happened. Y was admitted to hospital and paid a bill of 5 lakh rupees on recovery. Y asked X to compensate him the hospital charges for car and hospital expenses amounting to 60,000. So will you get it, people? Yes, you will get it. Extraordinary expenses, whenever the bailment is non-gratuitous bailment, meaning if the bailment is for hire, whatever are the defects, whether known or unknown, you will be liable for those defects. So can I recover? Yes. What and all I can recover? I can recover every extraordinary expense. Meaning here 10,000 is repair cost, I can recover. 50,000 hospital cost also you can recover. So yes, I can. Evergreen Private Limited has 9 directors on its board of directors. The company's articles of association currently state that the quorum for board meeting shall be 1/3. Same thing, people, which we already seen, entrenchment of articles, public company, special resolution, private company, 2/3. State with reasons whether the following companies can be treated as small company. STS Private Limited having a turnover of 10 crore and the paid up capital of 1 crore. Paid up capital is 1 crore. That is 1 lakh equity shares. Out of these, 60,000 shares are held by UB. That means STS is a subsidiary company and hence it cannot be a small company. ZX Limited having a paid up of 3, turnover of 35. ZX Limited, see name says limited, that means public company. A small company means a company other than public company. So no, it cannot become a small company. P sold certain antique items to Q for 3 lakh on 13th December 2024. As per the terms of agreement, 75% of the amount was to be paid within a week and balance 25% was to be paid till 31st December 2024. X appointed his agent R to take delivery of the goods. After the payment of first installment, Q transferred a sum of 2,80,000 in the account of P through NEFT on 18th December 2024. Balance has to be paid within 31st December. Okay. Which was credited in P's account on the same date. R failed to take the delivery of antique items due to medical emergency. By the meantime, Q failed to make the payment of the second installment till 31st December. On 10th January, Q's agent came to take the delivery of the goods, but P refused to give. Can I exercise the right to lien on 20,000 rupees? Is it possible? Of course, I can exercise, people. The due date is 31st December. Now the date is 10th of January. Can I exercise? Of course, I can exercise because the credit period is over. Right to lien can be exercised, valid. An auction takes place in Delhi for antique items. It is notified to the bidders that the sale will be completed only when the hammer of the auctioneer hits the table and he announces you are the highest bidder. During the auction, L bids for an antique sculpture worth 8 lakh. The hammer falls, but announcement cannot be made as the auction suddenly stops before the auctioneer can utter any word. It is notified to everyone that there has been an unexpected rise in the market price of the particular sculpture and therefore it will not be sold on the particular day. L contends that the auctioneer is bound to sell the sculpture to him at the price he bid because once he bid the highest price, the auction and the hammer fell, the auction sale was complete. Auction sale will be complete, people, based upon the customary actions that the person has followed or any other means. So in case it is clearly written, people, 3 times of hammer and you're the highest bidder had to be announced. It is not yet announced. And hence, people, the sale is not yet complete because it is not yet announced, which is customary. Simple. PQR are partners in a construction of PQ. P buys cement. Same thing. We need not do it again. The object clause of MOA authorized the company to carry on the business of trading in property in Gurgaon. Since the company was not doing well, the directors of the company in recent board meeting planned to diversify the business and enter into a construction business. For this, they borrowed a sum of 5 crore from Magnum Finance for the members of the company. Company refused to repay the loan. According to the problem, what is the recourse available to Magnum Finance? Okay. People, yes, it is ultra vires transaction. If you have borrowed the money for any other purpose, it is the ultra vires transaction. Company will not be liable. However, if company has taken the benefit of the money so borrowed, meaning we have borrowed 5 crore, in that some 2 crore rupees was taken a benefit by the company to repay some other debt. In such case, people, my liability will not come to an end. My liability will continue. So I will have to repay in such cases. Though it is ultra vires transaction because the company has taken the benefit here. S&M Limited was registered in 2021 with share capital 50 lakh divided into 5 lakh. Section 8 company promoting. Okay, company earned huge profits. Demanded for dividend, people. Possible, definitely not possible. Okay. Okay, explain the validity of the following agreements. Marriage bureau, which we already seen. Bharat agrees. White bull, which was dead. Mutual mistake, we have seen. Rishabh sells the goodwill. Omkar, which we have seen. Local limits, valid. A property worth 2 lakh was agreed to be sold for 25 on unsound mind. We have seen. Done. MNO Limited, a supplier of electronic components, entered into a contract on August 1st, 2023 with PQR Limited for sale of thousands units of microchips. Microchips, people, already done. Correct? Huh? Okay, A purchases a motorcycle from B and uses it for some time. It turns out that motorcycle sold by B to A was stolen. What will you do, da? I need to return the goods. I need to take back the money. Implied condition as to the title. Classify the negotiable instruments. A promissory note made in Kolkata, payable in Mumbai, inland only. Two conditions. Where it is made, payable, and where does a drawee reside. Made in Varanasi, on a person resident in Jodhpur, drawee resides in India. Yes, people, it is inland. Agra draws a bill of exchange in Agra. Residing in also Agra, bills of exchange also drawn in Agra only. A promissory note is made in New York, drawn outside India by a resident of New York. Two conditions also not satisfied. So I'll call it as foreign instrument. A bill of exchange is drawn in London on a person residing in Dubai. So two conditions not satisfied. Foreign. Done. Classify the following transaction according to the type of goods. A wholesaler, 100 bale, agrees to sell ascertained goods, existing goods. A agrees to sell 1 packet of sugar, unascertained goods. Done. The last one, sir. Rahul owns an electronic store. Pankaj visited the store to buy a water purifier priced at 54,000. He specifically requested Rahul for a purifier with a copper filter. As Pankaj wanted to buy the purifier on credit with the intention of paying in 9 monthly installments, Rahul demands a guarantor for the transaction. Suraj, a friend of Pankaj, came forward and gave the guarantee for payment of this water purifier. Okay. We'll see. Suraj came forward and gave the guarantee for payment of water purifier. Rahul sold Pankaj a water purifier of a specific brand. Pankaj made payment for 4 monthly installments and after that became insolvent. Explain with reference to Indian Contract Act the liability of Suraj as a guarantor to pay the balance price. Of course, people, it was 54,000 rupees. He has paid 4 installments. Correct? How much is each installment? They have not given. Okay, he has agreed to pay 54,000 divided by 9. 9 installments. You see how much will come per installment. Yes, 9 5s are 45, 9 6 are 54. So you need to pay 6,000 rupees every month. He has paid 4 installments. So he has paid 24. That is remaining people how much? He has to pay 30,000. When the borrower fails to pay, the guarantor will have to pay 30,000. What will be your answer if Rahul sold the water purifier misrepresenting it as a copper filter? In such case, people, the liability of principal debtor also will come to an end. Then the liability of the surety will also come to an end. A company DEF Limited as on 31st March 2024 had a paid up capital of 1 lakh. 10,000 shares. In June 2024, okay, once again. DEF. They have paid up capital of 1 lakh. Okay. They issued another additional shares of 1 lakh. So now it is 2 lakh. Out of 10,000 shares, 5,000 shares were issued to MNO Private Limited. Out of this, MNO Private Limited are holding how much? Total 5,000 shares. That is 50,000. MNO is a holding company of JKL. MNO is a holding company of JKL. Okay. Now JKL Private Limited claims the status of being a subsidiary of DEF Limited as being a subsidiary of its subsidiary MNO Private Limited. No, people, these are not subsidiary and holding. Nowhere they are related. Of course, they are not related. Okay, they are not related. No, it cannot be called a subsidiary company. State the relationship between DF and MNO. These two people. What is the relation? Who can tell? Of course, the relationship between them is people associate company because they are holding 25% of shares in the DF Limited. What is an associate company? A company which holds in other company a significant influence. Now, what do you mean by significant influence? Significant influence means people something which is at least 20% but not more than 50%. Ashish, a trader, delivered camera to Mohan on sale or return basis. Ashish delivered a camera to Mohan on sale or return basis. Mohan delivers the camera to Raj for sale for cash only or return basis. Raj delivered it to Vikas on sale or return basis without paying cash to Mohan. So R has not paid cash to Mohan. This is not paid. The camera which was in possession of Vikas was lost. Vikas lost the camera. Left though he exercised due care, meaning what? He has taken proper care. If not, you can say V is responsible. Referring to the provision of Sale of Goods Act, analyze the situation and advise whether Mohan, Raj or Vikas are jointly or severally liable. Who will be liable? People, Ashish gave his camera on to Mohan on sale or return. On sale or return, when will the ownership pass? Whenever you accept, whenever you keep the goods beyond the period. The third one, people, you do something equivalent to an acceptance. Here you have done something equivalent to an acceptance. You will further sell it only when it is yours, right? Yes or no? So here, sir, he has further sold it to Mohan. So, sir, ownership is transferred to Mohan. Agreed? Okay. Now Mohan is the owner. Now Mohan has given it to Raj, but Raj has not paid the cash. So there is a clear condition. Until the condition is not met, right of disposal is reserved. So ownership is not yet transferred. Money is not yet paid. So people, definitely Raj did not become the owner. So did Vikas did not become the owner. So whose responsibility it is ultimately? The entire responsibility is on the Mohan. Rest of them are not liable. Akash of Jaipur sold 100 smart TVs at 50,000 per set to Barun. He delivered the TV sets to Chirag, a transport carrier, for transmission to Barun. Barun further sold these 100 TV sets to Sarthak. Akash sold to Barun. Okay. Whenever names come in your exam, it is your responsibility to first write down it like this, sir. And don't write on question paper. Take pencil and write it in your answer sheet only. After everything is done, erase. Okay. He delivered the TV sets to Chirag, a transporter. Okay. It is given to Chirag, a transport agent. Okay. Barun further sold this to Sarthak. Ababa. On reaching the goods at the destination, Barun demanded delivery, but Chirag wrongfully refused to deliver. People, simple. See the words. This is what I call it as keywords. Whenever the goods are wrongfully refused to deliver by the carrier, the transit comes to an end. Agreed? That is why he failed to deliver the TV sets to Sarthak and suffered a huge loss on account of non-delivery. Akash came to know about this. He directed Chirag to stop the delivery to Barun and re-deliver the goods to him at Jaipur. Answer the following. Whether Akash has the right to stop the goods in transit? No. Transit has come to an end. Whether Barun can claim loss? Answer is yes, Barun can claim loss. Possible. Ram wants to incorporate a company. Okay, how you follow, you file form spice and all. Okay, done. Okay, Ram and Sham are partners in a partnership firm, RS and Co. Gaurav, a renowned businessman, is their common friend. Ram and Sham are the partners. Gaurav is their common friend. Okay. Ram introduced Gaurav to Sahil. Ram introduced Gaurav to another person called Sahil, a supplier, as his newly joined partner. Gaurav, knowing that he is not a partner, preferred to keep quiet. What do you mean by it? What is the answer? Partner by holding out. This information about Gaurav being a partner of the firm was shared by Sahil with another businessman. Sahil also told it to another businessman, it seems. Who? Madhav. Sahil told Madhav that, hey, you know what? Gaurav is their new partner. Who told? Sahil told. Next day, Sahil supplied the raw material on credit and Madhav lent 5 lakh to the firm for a short term period. So now what happens? Sahil and Madhav both have done a contract with RS. So the question is, people, simple. So if something happens, is Gaurav responsible for this contract? If yes, to whom is he responsible? Sahil or Madhav also? Of course, people, wherever he had an opportunity to deny, only with them he will be personally liable, not to the party whom they have further communicated. For Madhav, I will not be liable. For Sahil, I will be liable. Because with Madhav, I did not behave anything. Sahil was the person who told, not me. On admission as a new partner, Ashwin agreed to be liable for the existing debts of the firm by an agreement signed by all partners, including Ashwin. Examine whether Ashwin will be liable. Yes, people, you can be liable provided it's a novation. Only additional condition is that, people, in addition to the partners, even the creditors also should agree to it, not only you guys. Here they have only said the partners will agree, and hence people know. This cannot be considered as a valid novation. MN Limited borrowed a secured loan of 5 crore from Star Bank to meet its working capital. Same thing, MOA, ultravires. If you have used the money to repay, the utilization of the remaining 2 crore cannot be traced. The company's books of accounts show that the company has utilized a loan of 3 crore for repayment of its lawful debt. So even if it's an ultravires transaction, people, I can recover the money. Clear? After incorporation of Unique Private Limited on 15th May, the share certificates were issued to Arnav, Sohail and Suman, being subscribers to MOA of the company, without affixing the common seal. Is common seal mandatory? Common seal is optional from 2015. In the place of common seal, who should sign? 2 directors have to sign. If a company has a company secretary, then 1 director and 1 company secretary have to sign. So without affixing common seal and under the signature of Arnav and Sohail, the directors of the company, Arnav and Sohail, so 2 directors, is it valid? Yes. The company has yet to appoint CS, so there is no CS. Is it valid? Yes, it is valid. What if a company has a CS? Then it will be 1 CS and 1 director. Mr. R extended a loan to Mr. D with XYZ as sureties. Each surety executed a bond with varying penalty amounts, X with a penalty of 10,000, Y with 20,000 and Z with 40,000. People, co-sureties. To what extent? People, okay, see, the total amount they have given is 70,000. But what is the total default made? 42,000. Remember, people, as long as you can equally divide, you have to divide the loan equally. So 10,000, 20, 40 is the total difference, different amounts they have agreed. So to the extent of 10,000, all of them can be liable, correct? And there ends the first person's liability. Now still how much is pending? Still 12,000 is pending. Now the first person cannot be liable anymore. His liability comes to an end. The next person can be 20, 40. So I need to divide 12. So divide 12 equally. So what will be the liability? This person is 10k, this person is 16k, this person is 16k. Clear? Done. Important from exam point of view. Remember and go. X agrees to pay Y 1 lakh if Y kills Z. To pay Y, X borrows 1 lakh from W, who is also aware of the loan. So people, illegal agreements, agreements connected with illegal agreements will also be considered as void. So X agrees to pay Y 1 lakh if Y kills Z. So contract between X and Y directly it is illegal. X and W, because you are aware, W is aware that the money will be taken and given to this purpose. Any agreement connected people will also be considered as void. Karan agreed to sell his laptop to Vishal for a price to be fixed by Kiran, a hardware engineer. However, before the delivery, changes his mind and did not share any particulars and configuration of the laptop, which made her unable to do the valuation. So whenever any parties to the contract prevents the third party from doing the valuation, in such case you can avoid the contract, you can avoid it. You can also claim compensation. Vishal needed laptop for his project, so he promised Karan that if the laptop is delivered to him, he would pay a reasonable price for it. However, Karan decided not to sell his laptop to Vishal. Now Vishal wants to know from you, being a legal expert, whether Karan is bound to by his promise as he agreed earlier to deliver his shop. So people, if the possession is not transferred, people, then no, I need not have to pay the reasonable price. If the possession is transferred, I need to pay the reasonable price. Miss Meenu went to the local rice and wheat wholesale shop and asked for 100 kgs of basmati rice. The shopkeeper quoted the price the same as 125 rupees per kg, to which she agreed. Miss Meenu insisted that she would like to see the sample of what would be provided to her by the shopkeeper before she agreed upon such a purchase. Controversial question. The shopkeeper showed her a bowl of rice as a sample. The sample exactly corresponded to the entire lot. Corresponded to the lot. Miss Meenu examined the sample casually without noticing the fact that even though sample was that of basmati rice, but it contained a mix of long and short grain. Now people, the cook on opening the bag complains, okay, now Miss Meenu wants to file a suit for fraud against the seller, alleging him of selling a mix of goods, cheap quality rice. Decide the fate of the case and options open to Miss Meenu for grievance redressal. Now why I am telling you controversial is, people, in this MTP, which is in Jan series, they have said, people, it was Meenu's responsibility to check it properly, and because the sample corresponded to the bulk, Meenu will not get back her money. But if you go back any time before Jan, they have asked the same question in the exam also, they have asked the same question in the RTPs also, but the answer has been different. Why? Whenever you are selling the rice as basmati, there is a description and there is also sample. The institute itself in the past has given this particular question as sale by sample and description. The description is to be met. So when you say basmati, basmati has to be long grain rice. The institute itself had given. In this, people, they have given a different answer. They have just referred it to sample and they have answered it. According to me, this question is wrong. The interpretation they have taken is wrong. Clear? Mr. Y issued a check for 10,000 to Mr. Z, which was dishonored by the bank because Y did not have enough funds in his account and has no authority to overdraw. Examine as per the provisions of negotiable instruments whether Mr. Y is liable for dishonor of a check. If yes, what are the consequences for such offense? 2 years of imprisonment or twice the amount of the check. This or that or both. Check is 10,000, so it can be 20,000, up to 20,000. What would be your answer if Y issued a check as donation? Remember, check bounce case can come only and only in the case of legally enforceable debt. Donation, no, gift, all this are not the valid grounds for It's not the valid grounds for dishonor of a check. I cannot take it. Yes, sir. That's all, people. A quick revision of I don't know how many questions, but I hope, see, that's why I say seeing the questions will give you different perspectives of reading the same topic. Now, you might have read the same topic, but you might have read it in a different way. That's why I always say read multiple questions. So that's it for today. Tomorrow, let us meet again, people, with RTPs. Let us revise quickly 5 RTPs. And the last day, make sure you guys are looking at, and you guys are, learning something out of it. We will be practicing on how to write your answers. So thank you so much all. See you. Bye-bye.